Next from Springfield, we talk with Attorney Aaron Maduff, who represented the State Universities Annuitants Association in their lawsuit against the state over pension reform about the Illinois Supreme Court's decision finding pension reform to be unconstitutional. This runs about 20 minutes.
Aaron Maduff, thanks for joining us again on the Illinois Channel. As we tape this, the Supreme Court just a few days ago issued their much-awaited decision on Illinois pensions, and now that you've had a chance to review their opinion, give us, if you would, just first, what is your overall impression of the court's decision and the logic that they used in their argumentation?
The opinion itself is a masterpiece. It really is. The court had the advantage not only of the state's brief, but two briefs, one from SUAA, us, and an additional brief that came from the other four groups together. And yet when you read that opinion, it has items from our brief, it has items from the other brief, and it has a great deal of research that the justices obviously did themselves. There is citation to Dawn Clark Netch's testimony before the U.S. Congress, to SEC findings, to Pension Commission findings. They really did their research, and they really thought it out very carefully. So it really is an impressive opinion in my view.
You and I had talked, in fact, last time we talked, we were standing outside the Illinois Supreme Court after you had just made, one of the attorneys had made the arguments. One of the issues that the state had brought up and was the police powers, that basically they were arguing, in essence, if I have it right, that the state needs to maintain law and order, and we're under such financial pressures that we should be relieved of the pension obligation. I'm summarizing. The court wrote in part that the police powers defense is fatally flawed. What were your thoughts on that argument by the state and how the court ruled in that aspect of the argument?
The police power, or reserve sovereign power, has been the cornerstone of the state's argument all the way along. That's been its defense. We are in such a disaster right now that we must exercise the police power in order to save the health, welfare, and morals of the citizenry. And in this case, the economic welfare is where the state is coming from. And the state's argument talked in some sense, for example, about what's going to happen to the state's credit rating if it can't meet these pension obligations. Now, the argument that we've been making on the plaintiff's side is that the Pension Protection Clause of the Illinois Constitution is without exception. It is plain, it is unambiguous. It does not say, but you can exercise the police power at some point. The state argued that the police power is something that the state inherently has and inherently must use. In fact, one of the state's various arguments cited a U.S. Supreme Court case citing the Contracts Clause of the U.S. Constitution, and the state argued that under federal law, it cannot abandon its police power. Now, for a lot of reasons, we feel that they misrepresented the case, and that's not what it was really saying. But putting that aside, the point is that the state's view is that the Constitution doesn't have to say police power to include a police power. And therefore, because the pension clause itself doesn't say subject to the police power, is not defeating their argument that they have a police power. And yet, what the justices noted, and something that I think we argued vociferously, is that where the Constitution wants to reserve power to the state, it does so. The right to bear arms in the Illinois Constitution says the right to bear arms shall not be infringed subject to the police power. And there are several other provisions in the Constitution that say that the right to free speech shall not be infringed, but it has to be used responsibly. The right to a healthful environment shall not be infringed, but that's subject to reasonable regulation by the government. So where there's a police power, the Constitution says the government has some space to work. And our argument has been that the Pension Protection Clause is plain, it is unambiguous, it says that pensions are contractual relationships, the benefits of which shall not be diminished or impaired, and it doesn't say except when. That's all it says. And the Supreme Court came down very clearly and said there are no exceptions here. A constitution is a limitation on state power, and you cannot imply some power to override the Constitution simply because the provision doesn't say it. To the contrary. If you want to override it, it's like the right to bear arms shall not be infringed subject to the police power.
Since the decision came down, Governor Rauner said he anticipated that this would be ruled unconstitutional. He thought the way the bill was written, or the law was written, I should say, that it was unconstitutional. And yet, so now they go back to the drawing board. Now, from what I understand of the governor's position, he would argue, in essence, I could pay you $10 an hour, or I could pay you $100 an hour, let's say, on Monday, Tuesday, and Wednesday. But then I could say, I'm going to change that and pay you only $20 an hour on Thursday and Friday, at which point you can either accept the lower wages or leave. And I say that because he was going to argue that the pensions that you have accrued to this point could be changed going forward. As you read the opinion of the court, if the governor approached a rewrite of the pension reform with that in mind, that you could change it going forward as compared to going backwards, would that pass constitutional muster from what you can tell of the court's decision?
Absolutely not. Here's the difference. The governor's statement is very appropriate when you're talking about a private employer. Illinois is an at-will employment state. You can be fired at any time for any reason, so long as it's not an illegal reason. You can quit at any time for any reason. So, given that employment is at the will of the employer and the employee, now the employer comes back and says, it's no longer at my will to have this relationship. I'm going to change what you're being paid. It's now up to the employee to exercise your will. Do you want to be a part of this employment relationship under the circumstances, under the conditions that I, the employer, have laid out? And in the private sector, that works. The private sector is not governed by the Illinois Constitution. The private sector is not governed by the Pension Protection Clause. When people take jobs, we represent state university and community college employees, which includes faculty. And the greatest example I can give is somebody in a very highly technical scientific area. When they take a job teaching, they give up the opportunity to do things in the private sector. And they're going on to research grants and doing things that they're doing. And now this same discussion, of course, can apply in various different areas, but the concept is that they've given something up. And now they've been doing it for 20 years. They can't just say, well, okay, I'm going to quit and go find something else. In the private sector, you could have that problem as well, but the difference is the decision that they made to do it for the state was to have a pension that was protected by the Pension Protection Clause. And the governor's problem with his position is that once you enter into employment with the state, that is the act, that's the contractual relationship, the benefits of which shall not be diminished or impaired. Pensions are a contractual relationship, and the contract is that I'm going to work, I'm coming to work for you, I am starting work, I've done my first day, I've embarked on a path, and what you're going to give to me on the other side of the contract is that my pension is never going to be any weaker than it was the day that I took that job. I can trust in that. So I think the governor's position has been, well, if you're retired, we're not going to change your pension at all. But if you're still working, hey, you have the right to quit working or stick with the new pension. And the decision that somebody made to take that job, that was the act that entitled them to the pension. Not just continuing to work. They have to continue to work, they have to meet their obligation. But the state also has to meet its obligation to pay them the pension that they were promised when they started working.
Well, and let me remind the audience that there was the Canerva decision in July, and what I think was a bit surprising to some, again I'm paraphrasing, but the court ruled that the health care benefits that the retirees had were also part of their pension benefits and couldn't be reduced.
That's right.
So that that would seem to also, I think, bolster the argument you were just making, at least as far as the court's thought process on that, number one. But, well, first of all, let me have you respond to that. Would you agree on that?
I would agree. let's be clear on the distinction between Kenerva and this case. Kenerva was, if you will, the first shot. Kenerva was a case where the only question before the court was whether health care benefits are pension benefits such that they come under the protection of the Pension Protection Clause. The state was arguing that the health care benefits came under a different section of the code, and the plaintiffs were arguing that's fine, but it's still something you have by virtue of having been an employee of the state, and therefore it's a pension benefit, and therefore it is protected by the Pension Protection Clause.
Let me clarify something, because I don't know the answer to this off the top of my head. Did that apply, did Kenerva apply, were they trying to change the health care benefits of those who had already retired or those who are also still working? No.
This was a matter of those who had already retired, were already receiving health care benefits, and I believe it was Public Act 97-695 said, now we're going to take 1 or 2% of your pension each month, depending upon whether or not you have Medicare, and apply it towards the health care premium. And the plaintiff's response was, wait a minute, you already have an obligation to pay us, to give us this health care. We shouldn't have to pay something in addition for it, because that health care is a pension benefit that's protected by the Pension Protection Clause. Now, the distinction that we've got here is that in that case, the state did not raise the police powers. The state said, look, the statute didn't have listed all of the items that said we were in an emergency, and so they didn't bring it up in that case. So the police powers was not before the Supreme Court, and we had this discussion, I think, in some of our earlier interviews. In this case, we're now addressing the question of whether or not the police power can apply at all to something that is protected by the Pension Protection Clause, and the court has said quite clearly it does not apply. And therefore, in the context of health care, now that we know under Kenerva that health care is a pension benefit, we also know that the police power cannot be applied to deprive somebody of their health care benefits.
So, in essence, if the governor got a bill passed to reform the pensions on a going forward basis, your argument would be, or your warning to the governor and the legislature is, you're going to waste a year or 2 years and still have it thrown out again.
I think it's quite clear, yes.
Let me ask this. When someone starts working for the state, as I understand it, they're not vested for, I think it's a period of 7 years. I may be wrong on the period, but they're not vested automatically. What about, would the state be able to change the game on someone who started working for the state a year, 2 years ago, but isn't vested as yet?
Well, I think we need to be careful, because this opinion, this bill, addressed the Tier 1 employees. I believe in roughly 2011, the state for new employees had a new Tier 2 system, and the Tier 2 system was not addressed. I think your point is, with newer employees, let's say somebody from 2008, who would still be Tier 1, can the government change things because they're not fully vested, if I'm understanding your question?
Yeah, well, 2008 might be vested, let's say. But let's say 09, 10, because it was January of 11 that it went in. So 09 or 10, if somebody's not fully vested, could the game be changed on them?
And the answer is no. That's the short answer. But it's very complicated in that we need to keep our minds clear about the difference between a contractual right and vesting. A contractual right, which is what the Pension Protection Clause says this is that so long as you, the state employee, is performing your end of the bargain, the state has to perform its end of the bargain. Now, if the employee quits before the pension vests, the employee can lose the pension because the employee's obligation is to work whatever period of time it is, given the particular pension system's rules, until the pension vests, and to get that portion of their pension. But so long as they are doing that, the state can't come back and say, sorry, bait and switch, we're now going to say thank you for all that work, but we're never going to let it vest and we're going to change it. No, the employee, so long as they're doing meeting their obligations, the state has to meet its obligation and permit it to vest when the time comes.
Okay. So the short version would be that any reforms that would take place would have to be, I think you would be arguing, on new employees, people who had not yet started working for the state. You could obviously do anything you wanted. You could say we're not going to have a pension anymore for those people if you wanted to, and then they would come to work accordingly, knowing that that's the deal they're getting.
I think that's right. I have to be careful here because when you say no pension at all, there may be other legalities that I haven't looked at. But the short answer, and I think where you're going, is that once somebody has started working, whatever their pensions are, those can't be changed. If somebody has not started working, we can put in a Tier 3 that is something different than Tier 2, but even the Tier 2 people, you can't reduce their pension from what it is now.
Okay. Before we leave the topic, is there anything else we should consider or know about?
I think there are a lot of things in this opinion that are really important. One of the things that the state argued was that the police power comes into play because it's very concerned about its credit and its credit rating and the general revenue bonds. And I addressed that in the oral argument. That was very troubling to me. I believe we have approximately a $50 billion market in Illinois general revenue bonds, which the state is concerned about. And my comment to the justices is that if the state is permitted to say police power and stop paying its debts like pensions, what is going to happen to that market in general revenue bonds? If you're holding general revenue bonds and you now know that the state can yell police power and make them worthless, what are you going to do? And the Supreme Court recognized that very clearly, and it noted that if financial markets were rational, this would not buoy our economy, it would ruin it. I think that's almost a precise quote. The other thing that I thought was really interesting in this case was that the justices recognized with a great deal of research that the state has failed in its obligations to fund the pensions for a long time. I think we said nearly a century. I don't know if the justices laid it out quite to that extent. But that was very troubling. We talked about it after the oral arguments that Justice Thomas felt it was very troubling. And the state is coming back and saying that now that it has this problem, and that's when I raised the Lizzie Borden defense. I believe I said something along the lines of, I've killed my parents, have mercy on me, I'm an orphan. And the state's response is, well, what really happened here is that we got taken by surprise by this economic downturn. And this is something that was of concern to me from the very beginning. We pointed out in the very introduction of our brief that we've known that the economy has cycles since Joseph interpreted Pharaoh's dreams. To come back and say, we got taken by surprise by what we're going to call the Great Recession, I didn't call it that, the state did, was something that was troubling to me. And the Supreme Court recognized that as well. It was not impressed and was very clear that economic cycles are to be expected. And the way it's written, when you talk about the bond ratings, the economic cycles, these justices showed not just a tremendous amount of research, but an understanding of economics, an understanding of financing. I mean, this is a remarkably complete opinion that drew from my oral argument, drew from the other oral arguments, drew from our brief, drew from the other brief, drew from a tremendous foundation of additional research that I think makes it a truly remarkable opinion.
All right, Aaron Maduff, thank you for joining us.
Thank you.